WashingTECH.
There are many communities that have high-speed broadband running through their communities, but if the pricing is so out of reach, it does not matter that that service is available.
Are you worried about your kids' safety on the internet? We are here to help. WashingTECH's 5-step checklist will take you through the process of protecting your kids, and will give you tips on how to set up the best parental controls for your children on their devices. You want what's best for your children. They deserve to be safe online. Our step-by-step guide will help you make sure they are. Download WashingTECH's online safety checklist today to protect your kids online. Find it at protectyourkids.online. That's protectyourkids.online.
Welcome to the Tech Policy Leaders Podcast.
The world's most influential voices keeping you safe and informed online.
Streaming from Washington, D.C., America's tech law and policy epicenter. These are your leaders. This is the podcast.
Tech Policy Leaders with Joe Miller, founder and CEO of WashingTECH.
WashingTECH, safe and informed since 2014.
Hello, everyone. I am Antoine Prince Albert III, a government affairs policy counsel at Public Knowledge. I'm hosting this week's show for Joe Miller. And today our special guest is Belinda Nixon. Belinda is a partner at Perkins Coie law firm, where she provides strategic legal counsel on transactional and regulatory matters for communications, media, and technology companies.
It's wonderful to be here, Prince.
Yes, great. So let's start where you started in this work. What brought you to telecommunications policy? What piqued your interest in working in the mass communications sector? And please don't leave out the Hoya connection. We're both graduates of Georgetown University Law Center. So feel free to start there if you feel so moved, Belinda.
Absolutely. Absolutely. Thanks so much for this opportunity. So let's see. I graduated from Stanford undergrad and knew that I wanted to go to law school, but I wanted to get a sense of what the legal field is like. So I took a year off and I was a paralegal at Morrison & Foerster in San Francisco's office. And there I worked on securities litigation, which allowed me to realize that I did not want to do litigation. But I definitely did want to go to law school and came to Georgetown Law, and mostly because I realized even though I very much enjoyed being in the West Coast, I really felt like I was an East Coast person. And so coming to Georgetown Law, I had a fantastic experience. And out of there, I joined Pillsbury, Madison, and Sutro at the time. Currently, it's Pillsbury Winthrop. And I was doing, so I was there as an associate for several years. And then the 96 Act was passed, and the FCC was hiring just like crazy. And I was newly engaged and realized that for family life balance, it would make sense for one of us to, especially if we stayed in DC, to always be working for the federal government. And so I joined the FCC for that, but also understanding that to be successful at a law firm, I felt that it would be great to get a depth of knowledge in a particular area. And since, with the passage of the Telecom Act and everything with the internet was really exploding at the time, it felt right that the FCC was the right place to land. And so, yes, once I got there, it was interesting to see how vast the agency is and how many different kind of markets the Federal Communications Commission impacts and touches on.
That's great. And so fast forward a bit, right? You spent almost 25 years at the Federal Communications Commission, and the agency that regulates telecommunications products and services in the U.S., for those who don't know what the FCC is. And the agency has a public interest mandate, right? Something I know and care a lot about, Belinda, as a public interest tech policy professional. So how does the FCC's enforcement work to affect real people? How does the FCC affect people's day-to-day lives? And as you answer about, the public interest mandate and enforcement, Belinda, talk to people who have lost faith and trust in government institutions. What can you tell them about this work and these regulators?
Absolutely. And I'm so glad you mentioned that, because as an agency, that is a unique perspective that the mandate that the FCC has is considering the public interest. And it really drives a lot of what the work of the staff is. The staff is very focused on the public interest. And even, for example, like when there are merger reviews, which I worked on the SiriusXM merger review, and the review that the FCC conducts in order to grant a license approval, because when a merger happens that involves a company or an entity that holds an FCC license, in order for that license to transfer to a new party, the FCC has to grant an approval. And the standard that they look at the time and currently consider is the public interest standard. And is this merger, is this action, this transfer beneficial to the public? Typically, when there's a rulemaking proceeding, the rulemaking is put out for comment from the public. And we would get comments from industry, as well as consumer interest groups. We would get comments from Congress. And a lot of those comments, the entities filing would present us with different options on how we should proceed. And when the FCC staff takes a look at those comments, sometimes it can be challenging, because sometimes no one knows exactly which version or which option is going to be most beneficial to the public. Sometimes you're taking a guess, and sometimes there can be multiple options that are beneficial to the public. But I will say that is the interest that the viewpoint that the commission takes. So, Prince, and when we're talking about the commission's mandate being the public interest, one of the things that really drives or helps to buttress that is that when the agency puts a rulemaking out for comment, the agency gets comments from industry, as well as consumer interest groups, as well as individual consumers. And when they're drafting the next version of that, that rulemaking, or when they're actually making the rules and regulations, the arguments that have been presented that they are not accepting, the agency is very intentional about addressing those comments. So, for example, if they receive comments supporting a certain perspective, but they're not taking that perspective, they need to rebut or answer why they are not taking that route. And again, they need to support that. And part of that support is identifying the public interest in the road that they are taking and the options that they are pursuing. So there's accountability there that the mandate places on them. And because of the comment and reply process that's in place, they're accountable to that and are held accountable.
So people, consumers, as well as the people that represent consumers, like public interest orgs and industry, all really get a chance to be heard and responded to by the agency with their proposals or ideas, right?
Absolutely. And I will tell you, the staff is very meticulous about addressing comments that they are not pursuing, addressing arguments that they're not taking up. They actually, will address it. If you take it, it's typically addressed either in the body of the, rulemaking or in the footnotes, but a lot of the more controversial, larger topics will go to court. And in order to get that deference, the Chevron deference from the court, that federal agencies are allocated, you need to be able to back up the decisions that you made.
Belinda, I'm so glad you mentioned Chevron, which brings us to kind of our next point. You know, all of us in tech telecom policy are getting these constitutional questions, right, from concerned citizens or businesses about cases in the Supreme Court term, and not just the one that we all know about, Dobbs overturning Roe and Casey, which we might touch on, but also questions about agency power. And there's a lot of overlap, Belinda, between mass communications policy coming from the White House, Capitol Hill, and the Supreme Court these days. And many don't fully understand how the FCC kind of regulates and is implicated in those decisions from the various branches of government. So please help us understand how this new, shall I say, landmark case by the Supreme Court, West Virginia versus the Environmental Protection Agency, how will this case affect the FCC and mass communications law and policy writ large? I'm anxious for your take.
Sure. Chevron grants federal agencies deference in the decisions that they make, because the courts recognize that the federal agencies are experts in the areas that they cover. And so typically that's very supportive, and favorable for agencies. What this most recent ruling did, it didn't obviously take away Chevron deference, but what it seems to have done, and this is brand new ruling, and it hasn't been tested or interpreted by other courts quite yet. Mm-hmm. But what it appears to be doing is stating that when there are major economic implications that an agency is reviewing, the actions that they take must be mandated or granted to them through Congress. And by, I think what happens in federal agencies is when they're responsible for a certain area. For example, with the FCC, they have wide mandate from the 96 Act to regulate and deregulate the telecommunications space. And for example, a more recent example, and I don't know if we're going to touch on this a little later, but net neutrality, in the past years was something that under the Obama administration, the agency took a look at the services provided by internet service providers and stated that they should be treated as telecom services, which meant that they could be more strictly regulated by the FCC. And the FCC pursued that action through a rulemaking, and it was immediately challenged in court by industry, obviously by internet service providers, but it withstood the judicial reviews, and was in effect when Chairman Pai, who was nominated and appointed by President Trump, under his leadership, the FCC overturned its own ruling where it designated internet service providers as telecom carriers.
Right.
So it's my thought that if the FCC were to take a look at net neutrality today, not only would she need a fifth commissioner of her party to help facilitate that, but if the FCC were to pursue bringing ISPs under Title II and making them telecom carriers, designating them as telecom carriers, they would have a higher bar to overcome now that the Supreme Court has issued its ruling, its decision in West Virginia versus EPA. And it's because although Congress has, delegated a lot of authority to the FCC in its regulation of telecom, there would be a strong argument to state that the that Congress did not grant them the authority to bring telecom under Title II authority. And in order to have that happen, Congress would need to act and specifically grant the FCC that authority to bring ISPs or other entities within Title II of the Act.
So if I'm understanding right, internet service providers were once upon a time under the Obama administration, right, considered as common carriers, right? They had the kind of heavy regulatory scrutiny that a phone service would have or a wireless telephone service provider would have. And then they didn't, right? Under President Trump, it's kind of like the agency said, Chairman Pai said, the agency doesn't want to control or regulate internet service providers like phone companies because they're not. And in fact, the agency may not even have the power to do so absent Congress. And it's interesting. I'm thinking of, a weird law school analogy of like Marbury versus Madison, right? Where like the court is reserving its right to do something in a space, but just deciding not to do it right now, versus Pi, which is a very kind of mixed, weird analogy. Whereas in a federal agency that's independent, kind of under Congress's oversight, the agency is deciding to not undo its regulation of certain market actors and saying that it actually can't, absent some congressional grant of authority to control those. And, is that true? Would you say that's it? And under this kind of new rationale of the court in West Virginia versus the EPA, it's kind of leaning towards Congress needing to empower this agency to do more as telecommunications evolve and develop. What are your thoughts on that? Am I right? Am I misremembering what our law school precedents? Please just inform me.
Prince, you are right on you're spot on. And obviously, your knowledge and depth in this area really shines through, and you hit it on the head. The agency, as you said, as opposed to reserving the right and saying, we have this right, but we are not going to use it at this time. Mm-hmm. What they actually said under Chairman Pai was, we never had this right. We should not have used it. And we can't use this right unless we get congressional authority. And Congress requires us to do this. I think the West Virginia EPA ruling is really in line with this conservative Supreme Court. Mm-hmm. Because I think the conservative philosophy has been that for quite some time, federal agencies have really been expanding their authority beyond their congressional mandates. And the feeling, I believe, on the conservative side is that obviously, yes, we do need federal agencies, but they need to stick close to what they were set up to have oversight on. Mm-hmm. And so this is a way for this court to signal to federal agencies that, yes, you have authority. Yes, you have Chevron deference, but you must stay within certain boundaries. And if you feel, that you need to act outside of that, you need to signal to Congress somehow that authority needs to be granted to you. And if, barring that, if Congress does not grant you that authority, you do not have a role to act in certain areas, especially, again, it's not everything. I don't, and they're not nitpicking in a sense, because they, did, focus on items that would have large, major economic impact. Mm-hmm. And so on those types of decisions, the court is saying, when you're having such an impact on our economy, you need to have the backing of Congress to do that, the support of Congress to pursue those.
Plugged into the WashingTECH Tech Policy Podcast, the inclusive voice of tech policy.
When I think of economic implications in telecommunications services, Belinda, I'm thinking about infrastructure, right? All this talk about infrastructure build-outs, revolutionizing telecommunications products, and we need to talk about the unserved and the underserved. Pew reports that about 21 million Americans still lack access to broadband. There are some, surveys that say that's larger or even larger than that. And those stats cut across race and income. Now we've got the Biden administration, especially Vice President Kamala Harris, having undertaken efforts to expand broadband access. And FCC Chairwoman Jessica Rosenworcel has initiated a digital discrimination proceeding to seek input about how the agency can and should promote equal access to broadband services. So between the executive and the regulatory pushes to get more people connected to the internet, what are the best interventions here?
President Biden and his administration got it right. Part of it is funding. And so the funding that's being provided for broadband build out is historic. Mm-hmm. And without it, definitely, no question, we are not going to be able to move ahead. Mm-hmm. I think another aspect of it, and you touched on it, is trying to identify very specifically where services are lacking. So that's one aspect, and the FCC is approaching that in terms of being able to identify with its broadband mapping project. And that proceeding is ideally going to help not only industry, but consumers. Consumers are going to be empowered to identify areas where service is lacking. Industry is going to state, we are providing service in X neighborhood or in Y area. And consumers are going to be able to have the ability to run a test, a speed test, or an access test, and demonstrate that they do not actually have service, or they don't have it at the requisite speed levels, and they will be able to directly file that with the FCC and be able to challenge the maps that the industry has put out indicating where service exists. So identifying where we actually have unserved and underserved is key. And the digital discrimination proceeding that you mentioned will tackle another aspect of the reason why people are not or don't have access, and it's from uptake. For example, you can have, there are many communities that have high-speed broadband running through their communities, but if the pricing is so out of reach, it does not matter that service is available. Or if there are other roadblocks to why people are not purchasing or don't have access to broadband, and the digital discrimination rulemaking is helping to identify some of those reasons. Part of the reasons are, as if you look at the comments that have been filed, are because people aren't aware of, what the uses are, what the benefits are for them. Another roadblock to people getting access to broadband is they might not have the proper equipment. So you could bring the broadband to someone's footsteps, but if they don't have access to smartphones or computers, again, you're not going to get uptake. And so the digital discrimination rulemaking is helping to identify the reasons why people, once access is provided to them, why they are not taking those up. And the commission does have a congressional mandate. So the digital discrimination rulemaking is a direct result of Congress's mandate to the FCC to research this. And so the commission is going to have wide latitude to be able to implement rules and regulations that directly address the sources of the lack of broadband uptake by certain sectors of our economy. Content producers also need to be diverse and have access to have the creative, their creativity be afforded the widest audience.
Yes.
And so there's there's several factors on to this topic, but those are key, and I believe the commission is tackling them, and they are they have the mandate, they have the authority to tackle them. Congress has spoken.
I agree. I think I have to agree for sure on that point, Belinda. And I'll just say you explain communications law and policy in such like an intriguing and readily digestible way. So I've got to ask you just a few more things before we sign off. But, I'm thinking about consumer privacy, consumer safety online, trust in the political information that we're seeing online, medical information, other things. How might this administration, this Congress, or these agencies, right, in this regulatory period, how might any proposals you're thinking of or ways that you're thinking about privacy, safety, and trust in information shake out now? What would be best and constitutional ways that we can just really bring people relief and confidence in their services and information that they deserve?
Absolutely. When we talk about some of the reasons why people are not signing on to the internet, definitely concerns over privacy are top of mind. And it's especially for people, if you're already kind of hesitant to use internet services, go online. When you hear about the privacy breaches that happen, clearly that's going to inhibit people further. But even for people who are very excited to be online and, younger generations who spend, several hours online, privacy concerns are top of mind. And it's not just here, in the US, it's internationally. We often think about certain countries, like even China, where we think maybe the public there is not as concerned about their privacy, but recent, actions there, privacy mishaps there have really identified that, or privacy breaches have identified the fact that no, people everywhere are very concerned about the amount of information they divulge, not only to government entities, but to private entities, and it's top of mind. So what's happened here in the US, because the federal government has not taken swift action and putting into place strong regulation protecting privacy outside of HIPAA. I think HIPAA has been very successful and actually should have offered a roadmap for what the federal government could do on a broader basis sooner. It has not, unfortunately. So what happened was in the states, several states have issued their own privacy regulations. The main one being California, that is probably the most stringent and most protective of consumer rights. And again, in the void of the US federal government acting, the EU and several other countries have also issued their own regulations. And now we're at a point where, absolutely the federal government, our Congress has to act. I think the public is pleading. And I think actually, it would also benefit industry. Because at this current stage, if you have each state issuing their own privacy regulations, that is a heavier burden on business. They have to be aware of each and every one of these, regulations, these laws, and they need to make sure that they're complying. And so that makes it challenging. It's business prefers predictability. And if you can't predict what every state is going to come up with as their privacy law, then that makes it challenging. So I think there's an opportunity. Most recently, there's been some action from Congress on the American Data Privacy and Protection Act. And it's been around and kicked around for a while, but I think in the past few weeks, there's been renewed energy. And again, this energy is coming from, it feels bipartisan. And so there's an opportunity, even though we're heading into the August recess with Congress, and after they come back, Congress is going to be very focused on midterm elections, especially the House, and several Senate offices will be focused on the midterms. But a bipartisan, act that really has the consumer's interest, that could be beneficial for all around. And if it doesn't happen, prior to the elections, again, there's the lame duck time period of time after the election that, again, it could be interesting time for some action there on privacy. But it is top of mind. There are certain areas that the FCC covers that are just arcane, feel arcane to the public, or just don't really get a lot of interest from the public. But I would have to say privacy is one area that, a lot of people can jump on board, and it's not obviously not just the FCC, but FTC as well. But privacy is one area that the public is very interested in, and it kind of is a bipartisan issue that really needs to be addressed.
Very interesting. Okay, Belinda, you've given us so much to think about here on so many issues. Do you have any final thoughts to leave us with, as well as where can we find you online?
Absolutely. So, one thing we didn't touch on is the FCC recently kind of started asserting itself a little bit more in cybersecurity. And I believe this is also very topical for consumers as well. And not just with, Chinese, made equipment, like with Huawei and ZTE and the purchase, the buyback of equipment. But recently the FCC, revoked licenses from Chinese telecom companies. And so that's an area where several agencies, the federal government, have, oversight on cybersecurity. But it's clear the FCC wants to identify cybersecurity as an area that they also have a strong impact and influence over. And it's kind of, I think most recently has asserted itself there. Yeah, that's one area I would think that we should be on the lookout for as cybersecurity issues, as well as privacy issues, start kind of being in the forefront more and more of our consciences.
Maybe next time we can have you talk about a little more cybersecurity and privacy and how they dovetail together, which is very, very interesting. Yeah.
I would love that. Thank you very much, Prince. This has been fantastic. I just want to say thank you. Again, you have such a depth of knowledge in this area. It's just been very fun to have this conversation with you.
Thank you so much, Belinda. Everyone, Belinda Nixon, a partner in the communications practice of Perkins Coie. Take care, everybody.
WashingTECH,